This week we had a very special guest in the studio, Steve Sumner. He's an attorney with Sumner and Todd up in Greenville, South Carolina. I want to thank Steve, first of all, for taking the time to be on our program, but also I want to thank him for supporting us through our advertising. He's one of our advertisers on our newsletter, on the website, and on our sister site, palmettowire.com. So I want to thank him for doing that. If you've got a DUI issue, upstatedui.com is the website for his firm. Great site name. I wish we had a cool site name like that. But Steve sat down with us this week, and we talked extensively on an interview that's going to air in its entirety at a later date. But right now, we wanted to zero in on one section of our conversation, given his expertise when it comes to boating under the influence laws in South Carolina. Now, obviously, if you've been following the Murdaugh murders true crime saga, the case that really launched this story on the statewide stage anyway was the 2019 boating under the incident trial of Paul Murdaugh. Actually, it never went to trial. Paul Murdaugh was shot and killed prior to going to trial, but the boating under the influence charges that were brought against Paul Murdaugh in the February 2019 crash that killed 19-year-old Mallory Beach of Hampton, South Carolina. Again, this was the crash, this was the case, this was the story that really took the Murdaughs out of the 14th Circuit and sort of broadcast them onto the statewide stage. And frankly, it's that scrutiny from that case which has led to all of the unraveling that we've seen in this big story over the last 2 years. So with that being said, let's go to the tape. Let's see what Attorney Sumner had to say about that case in particular, and about the boating under the influence laws that could come to play as that case on the civil side moves forward.
As it relates to Paul Murdaugh, because of the tragic and unfortunate death of Mallory Beach, it would have been a felony BUI. In other words, death resulted
he was hit
from the unfortunate.
3 of those,
yes,
as a matter of fact.
Yes.
And faced, I believe, over 30 years in jail on just one of them.
Correct.
And by the way, if we ever go on a boat, you're in luck. I got 15 years sober, so you can knock a few back, you'll be in good shape.
Fantastic.
But looking at the Murdaugh case, again, there was a lot made at the time. This was sort of the incident that kind of exposed this whole situation in the Low Country with the family, with the firm. It was what began to draw people's attention to this circuit, to the influence that they had down there. But ultimately, we're talking about a crime.
Yes.
All that stuff matters, but when it comes to this particular incident, it's a crime. Tell us a little bit about what's your assessment. Obviously, there were some reports last fall. Dick Arpulin, you referenced a moment ago.
I did.
He and his partner, Jim Griffin, made some assertions to one of the papers down there in the Low Country about here's how we would have defended it. How much of that have you followed as far as the case, about the defenses they were looking at?
Well, I know a little bit about the case. I've read where the craft was going in the range of, I think it's been estimated between 30 and 35 miles an hour, something, and I would defer to you on that. I think you probably have more knowledge. In Archer's Creek, which is a very narrow body of water. I think any lighting that was used was handheld flashlights or something along that line. First of all, 30 to 35 miles an hour is a pretty steep clip in the water.
Yes.
I have been, and I'm sure you have been too, on a boat doing 35 miles an hour, and it's no mystery why people would be ejected from the boat upon striking, the bridge or the whatever was there.
It feels faster too.
I mean, it's fast. It's very fast. We know that there were witnesses there. We've seen and heard from them about various, I don't want to say cut-up type maneuvers, but things that were alleged that Paul was doing while he was driving immediately prior to the crash. And we know that, and I neglected to mention this earlier, in a felony situation, a person does not have the right to decline any test. Right. And I didn't really cover that, and that's because, I know we're a little bit limited in time here, but a person has the right to decline tests. They can they can decline the breath test, they can decline blood or urine, but not in a felony situation. They cannot. Okay, right. So we know that I believe that It's been reported that Paul's blood alcohol, I want to say, was 24, something in that range.
Right. Three
so
times the limit we were
three
talking about earlier.
Right, and that's not an unfair statement when you say the legal limit, because most people view it that way. But that's 3 times the amount from which a jury could infer that someone is guilty.
Tell us the term of art here. I want to make sure we get it right.
Well, I appreciate that. It would be an inference. It's not a presumption, and that is important. It is not. It's an inference that can be combined with other evidence. What would the other evidence be here, Will? Well, it would be the people on the boat. It would be the witnesses on the boat. It could be people that saw them. I believe that the group was at a bar. I think Luther's, if I'm correct. Luther's. They maybe the state might pull in 5, 6, 7 people that saw them at Luther's to simply say, I thought they were under the influence. I thought all of them were under the influence, and I wouldn't have ridden in a boat with them.
Right.
I mean, that would be more evidence. So you would see that. You would see the potential, any video footage, which I have not seen, of Paul, interviews, should this person have been driving, interviews of witnesses. So that would have been really what would have been the gravamen of the state's case should this terrible tragedy have not happened of his death. That would have been, I think, where you would have seen. I don't want to say plain vanilla. That's not really. I don't know if I'm getting that across right to our viewers, to our listeners. But that would have been. That's generally what is involved in a BUI or DUI prosecution. Is what we'd call plain vanilla. It's not a document case, and I know that there have been, a lot of documents regarding some allegations against Ellick, in unrelated matters.
True.
It's not a document case. It's more of just a fact case of me. If I'm prosecuting the case of the witnesses, are there 3 witnesses? Are there 5? Are there 7? Is there video footage? Are there people that say he shouldn't have been driving? We have the actual wreck itself, which is indicative of not being able to operate, the way a prudent person would, and also we have the speed of the boat. So I think that would have probably been where Alan Wilson probably would have taken it. I don't want to speak for him, but I think that that's probably what the bulk of his case would have been about.
Well, I wanted to ask you about that case. One of the things that surprised me in the immediate aftermath of that, we kept hearing that given the influence of this family, given who Paul Murdaugh was related to, that we shouldn't expect too much from the Attorney General's office, that this was going to be a slap on the wrist kind of case, that there might be a reckless driving thing, but that Paul was going to get out of it. And indeed, if you look at the dash cam videos where you see the law enforcement officers talking to the other people on the boat, they're saying he's going to get away with it. He's a Murdaugh. What do you think you're going to get
what are
this
you going to
guy?
accomplish?
Right. Based on, and again, I want to take sort of the politics and the public focus on the Murdaugh saga out of this. Just looking at the facts of this boating accident, when you saw the charges that were filed by the Attorney General's office, what was your response? Were they fitting?
No, I mean, I thought that they were taking it fairly slowly. They were. I think there's been allegations that some evidence was mishandled potentially at the scene. I heard that maybe even a family member of Paul took the boat away. I think there were a lot of concerns regarding how evidence was handled. To kind of follow up on that, if I can, Will, there's something called a chain of custody. And when you have physical evidence, you have to show who handled that evidence and how they handled that evidence from the time it was taken, picked up, until the time it was analyzed. And if you have a significant break in that chain, then you've got a real problem in that coming into evidence. And I'm sure that Richard and Jim were looking at every potential angle there, and the fact that when you have more than one person in a boat or in a car, particularly in a boat where ease of movement is much more likely to happen, than in a car where
Absolutely.
you'd have a compact seat or things like that. Then you have to wonder who was driving. Can they prove who was driving at the time? So you have a lot of different things that the defense is going to explore.
So it would have been a tough case for the prosecutors.
I think it could have been. I think, obviously we're speculating here because of what happened, down in Colleton County in a terrible, terrible tragedy.
Sure.
But I think there's a lot of room, to work. And, Richard is a wonderful attorney, as is Jim Griffin. So I'm sure they would have used explored every avenue, zealously working for their client. Which would have been Paul at that time, regarding putting up the very best defense that they could.
Definitely. It was interesting to me also in looking at the negotiations behind the scenes in the aftermath of those charges, because one of the things I kept hearing from my sources who were very close to this case was that there was no room to negotiate as far as the state was concerned regarding the plea.
Right.
And I think a lot of this was, again, this is before the Moselle shootings.
Shooting.
So this was, obviously the case was at a very high energy level even before then. And I think it's important, as folks who have just started to follow the Murdaugh saga, a lot of them don't realize how big this was a big story before.
Huge case, big story. You do have a very prominent family, a very well-known family. You do have all the elements of, a William Kennedy Smith type,
Sure.
situation. I mean, I know you have the Kennedys, in the Northeast, and really they're equivalent, so to speak. And I know the Murdaughs are very humble people, but you have that same dynamic present. And so you have Paul, again, a very high-profile person from a very high-profile family. A tragic death occurs. I don't want to say this because I'm not a part of the legal
Sure.
team on either side, Will, but you have aggravating facts.
Right.
I mean, you just some cases are not that way. This was aggravating facts in terms of the speed of the boat, where the boat was, and all the things that we've kind of touched on make it aggravating. We have a death. We don't have an injury.
Yeah.
We don't have an injury. We have a death. We have, unfortunately, a beautiful young lady that is missing for, I think, a week or so, and then her body is unfortunately found. And then typically what you have then is you have a lot of victim input. And I don't know her family at all. I've seen her father interviewed. I've seen her mother interviewed. But when they stay behind something, when a victim stays behind something, the prosecutor has less room to move.
Right.
Yeah.
Because
Less
they're
room to
holding the
move.
prosecutors
Correct.
accountable.
They are. Ultimately, it's the prosecutors. We do have a Victims' Bill of Rights in South Carolina where they get input, and they get input on a bond. They get input at various stages of a case. Ultimately, it's the prosecutor's decision. But in reality, Will, when you have a family united and very vocal about what they want to see, then they've got a client too. And typically their client is the state of South Carolina. But then it becomes a dual client relationship. Not only is it the state, it's this family. And that's what you see.
And not only the family, they are obviously represented by an attorney down there.
They are. Yeah, Mark Tinsley, I believe, represents them. And again, a lot of great lawyers involved in the case on both sides. And, I think Mark, I don't know, but I know that you wanted to talk a little bit about the civil side of this. Yeah. And I'll just go ahead and jump in on that.
Yeah.
You have potentially, and I would certainly defer all this to Mr. Tinsley, but and maybe Justin Bamberg as well, and Eric Bland. I don't know Joe McCullough. I think there's a lot of different people.
There's
involved.
a lot of them, aren't there?
A lot of different people involved, a lot of wonderful lawyers. You might have something called a dram shop action, where I believe there's video of Paul buying beer, alcoholic beverages, maybe a couple of cases of beer, or a couple of 12 packs of beer. You have potential liability. I believe it's alleged that a false ID was used. I don't know.
That's true.
And so you have potential liability against parkers. I believe that the convenience store is Parker's.
That's correct.
In South Carolina, anybody that sells alcoholic beverages must carry a $1 million liability policy. So I'm sure that Mr. Tinsley is looking at that. There's also insurance on the boat itself. Okay.
Which was owned by his father.
Right. There's insurance there. There's a potential of a negligent entrustment action, which we discussed a little while ago prior to getting this visit going. And that is whether or not, if the boat belonged to Ellick or belonged to Randolph, whether or not they were on notice that Paul should not have been driving the boat, or Paul should not have been in a position to be able to drive the boat. So you have that. You have potentially homeowners insurance that sometimes can apply. And you know, you've got going after personal assets. So there's a lot of, I think a receiver's been appointed.
Yes.
You have a lot of different areas that you can pursue, and I feel like that they will be pursued. I think that Joe McCullough, I believe, represents a person that might have initially, some blame might have tried to have been put on that person whose name I don't remember for driving the boat. I know that I think Joe's pursuing that, so pursuing that angle. So there will be a lot. Now the focus will go as it relates to the boating accident, and I know that there's been a lot of other things that have happened.
Yes.
The genesis, the boating accident, you're going to now see that shift because of Paul's death, and Maggie, Ellick's wife. You will now see, I think, a big shift to the civil side of the case and financial compensation, which is how we handle it in this country. You know, we don't barter anymore. You know, I mean, years ago, as I may be drawn on too much, we would trade things out, and that was a way that things worked. We reduce, excuse me, we reduce things now to money, and that's how we negotiate. That's how we buy gas and groceries, and everything we do is reduced to money. So now that will probably be at the forefront of that particular part of the case.
And the plaintiff's lawyers, you mentioned a lot of those who are involved, they stand to do pretty well on that.
Yes, they do. They do very well. There's some wonderful lawyers in that area, and I know Mark's partner, Woody Gooding, known him a long time, a wonderful attorney. I know Mark's a great attorney. There's a lot of really fine legal work from virtually every angle. In the case, you've got some of the leaders of the South Carolina bar in terms of reputation that are involved in the case.
Sure. And I know your time is precious, but as we want to ask you one more thing about, as we kind of pull that lens back on the civil action.
Yes, sir.
One of the things that we were talking about was how the focus is shifting from obviously the criminal case, which ended with Paul's death.
Right.
Paul was actually never charged civilly. There was an expectation he would be eventually.
Right.
But prior to his death, he had not been implicated in the civil action. It was his father who owned the boat, his brother who allegedly provided the fake ID. It was Parker's, as you mentioned, and then there were a few other establishments that settled.
Right.
Out of
maybe
court.
Luther's.
Luther's.
Yeah,
Correct.
Luther's, where they were immediately prior to getting on the boat.
But to me, one of the most fascinating components of the civil case has been to watch how Parker's and their attorneys and the private investigators they've hired have sought to handle it, because it seems to me there's basically two defendants standing. There's Parker's and then there's the Murdaugh family. And it's just been fascinating to watch the behind the scenes maneuvering by the attorneys, the investigators they've hired, the public relations people they've hired. But that to me leads us to, again, a question of, okay, there's all this spin, there's all this blame, there's all these stories floating around, but again, it's ultimately going to be a case based on the law. Tell us a little bit, and again, I know you deal a lot in defending on the facts of the DUIs, but the tort component, the shared liability. Tell us a little about this.
Well, in South Carolina, we have something called joint and several liability, which means that there can certainly be more than one party that can be deemed responsible for what occurred. It is not uncommon, Will, to see a lot of negotiating going on because you have varying degrees of culpability. I had mentioned the negligent entrustment action potentially. Was Ellick on notice that Paul should not have been driving? That would involve his history. That would involve, was it one incident? Was it 4 incidents? I don't know.
Should he have had access to the boat?
Yes, exactly,
Right.
exactly. I thank you for clearing that up. I might not have made that clear to the folks that are watching and listening. But how many incidents were there? Were there witnesses to those incidents? I mean, how strong can you put that together? With Parker's, it appeared to be a quick transaction from the video that I've seen. The 2 young men look a whole lot alike. What you're trying to speculate in terms of the civil action, which is a lower standard of proof, Will, we talked about that. That is
Tell us
only,
one more time
that
for
is only 51%. Is it more likely than not that it is in favor of the plaintiff? Whereas criminal has been defined more in the 80 to 90% range beyond a reasonable doubt. So you have a very different standard of proof. But you're looking at this and you're trying to figure out what would a jury do. And you tend to see, or it's not tend to see, it happens 100% of the time, a whole lot more negotiating goes on with civil cases than typically with criminal cases. Right. Because if you've got video, again, not to go too far into it, but if you've got video, if you've got 3 witnesses that saw somebody try to break into your home and they can be identified, there's not a whole lot of room to move on something like that. There's no real mystery as to what happened. But with what I've talked about, with the dram shop potentially, and that's DRAM, a dram shop action against Parker's for not using prudent and good solid business practices in the sale of the alcohol, and the negligent entrustment action that we just talked about, there's just a lot more room to maneuver on both sides. And there's nothing wrong with that. It's just people are trying to, lawyers and mediators and judges are trying to sort things out that are not nearly as clear.
Yeah, and as you mentioned earlier, it does on the civil side, it reduces to a dollar amount.
Correct.
In
It
most
does,
cases.
and a lot of people feel negatively about that, Will, in terms of, well, they've settled for money. It's all about the money. Well, money is just how we operate. It's just how, if we're going to go buy a car, we buy it with money.
Right.
I mean, that's just kind of what we do.
All right. Well, Steve, I want to thank you for coming in.
Sure.
Also, again, thank you for your support of what we're doing here. It means
Absolutely.
a lot. It helps us do
And
what we're doing.
congratulations on the success that you've had.
Thank you, sir. We are trying, but definitely want to get you back down here. Obviously, we didn't get into the maritime law, which I know we want to talk about some point.
I do.
It's
I
a
do
factor.
and I'm glad to come back down anytime and talk about that angle of it, because it was not a lake. We were talking about an ocean, and we're talking about a creek, and we got to talk about that part of it, and I look forward to seeing you again.
No doubt. And we'd also want to get you, I was a little jealous. I looked on your website. I've seen you've got some columns in some of the other papers in the state. Would love to get you to share some of that wisdom on a guest post on FITSNews if we can convince you.
Absolutely.
We'll twist your arm on that. But
absolutely. Thank you, Will.
no doubt. Steve Sumner, Sumner and Todd, upstatedui.com. Again, a great URL for all your DUI needs. And again, he's going to be a regular guest on our program moving forward. So thank you, Steve, for taking the time.
My pleasure. Thank you, Will.
Yeah, man.
Take care.
Yes, sir.
All right. Bye-bye.